Something as easy as filling out or not filling out a form could mean the difference in how your spouse receives or doesn't receive the money that you saved in retirement. If you're a little curious on what I'm talking about, then stay tuned for this episode of the FERS Federal Fact Check. Hi, I'm Micah Shilanski with Plan Your Federal Retirement, and welcome to this episode of the FERS Federal Fact Check. We have a great question that has come in from a longtime podcast listener, Robin, and it really asking several questions that we need to dive into. One on beneficiary forms, how important are they or not, but also how do trusts come into play with beneficiary forms? And what she doesn't ask in here, but we need to talk about is Aunt Iris. That's right, our favorite aunt, the IRS. How does that come into play with beneficiary forms, trusts, and taxes? So let's get into Robin's question. Robin says, I love your podcast. Well, thank you, Robin. We appreciate that. We have a lot of fun putting together. All right. I love your podcast, and I'm a federal employee with the TSP and Federal Employee Group Life Insurance. I am fine with the standard order of procedures of beneficiary assignments being spouse, then children, and equal shares. I understand this order proceeds is followed when no beneficiary forms are on file. I have not submitted any beneficiary forms. Is there an advantage/disadvantage to filling out a beneficiary designation forms to restate this same assignment? What are the advantages, disadvantages of naming my Revocable Living Trust, husband and wife, as the beneficiary? Robin, that is a fantastic question. Thank you so much. There's a lot of moving pieces in here, so let's kind of dissect it one at a time. The first thing you brought up, and this is a question I get quite frankly, because I'm very adamant, I think every single person should fill out a beneficiary designation. You should have primary beneficiaries and contingents. God forbid, if something happens to you, where do you want your money to go primarily? So if you're married, husband and wife, husband passes away, sorry guys, I always pick on you, husband passes away, then where do you want your money to go to your wife? She should be listed as your primary beneficiary. You should have a contingent beneficiary. That's your backup. Something happens to the two of you. Where do you want your money to go? This is also where I say if you don't have a contingent beneficiary, you spell the name Micah, M-I. No, I'm just kidding, right? You need to have a contingent beneficiary out there and listed. This is very important. Now, Robin, you bring up a solid question. It says, wait, I'm going to name my spouse and then my kids, and that's the same thing as the default order of precedence that it says, and I shouldn't have to fill out this form. Why is Micah saying I need to do it? Great question. Let me tell you a story. I was meeting with a couple, a federal employee. They attended one of our retirement classes, and they came in to learn a little bit more information. And it was Bob and Sue, right? I'm sitting there and chatting with them. And as I'm reviewing it, I'm looking at their TSP statement. Now, this was before the TSP, by the way, a while ago, 5 years ago and so now, when they had the beneficiaries on the TSP form. Then they went through a gap about 4 years where they didn't put them on. Now they're putting them back on, which I love. So on your TSP statement, it actually shows now your primary and contingent beneficiaries. If it doesn't show it on there, that means the TSP probably doesn't have a record of it. So this was back when you could see them in the first version of it. And Bob and Sue, and I look at Bob's TSP and I look down at the beneficiary and it says Kate. And I'm like, holy crap, am I calling her the wrong name? And I look over the taxes. Bob and Sue, Sue is her name, her middle initial is not K, and Kate has a different last name. So his primary beneficiary of his TSP is a different woman on there. So this is an awkward conversation, but some I need to bring up. So I get the form, I spin it around, I push it between the two of them and said, do you guys mind telling me who Kate is and why she's the primary beneficiary of your TSP? He got red, she got pissed. We had a lively conversation, we kind of cooled things down, said, hey, let's call the TSP office, find out what's going on. We called the TSP office together. The TSP had put the wrong beneficiary form on file. He didn't have one on file. This overwrote what his default precedences. Now, if he would have passed away, it was not his fault. He didn't submit this form. He was going the same thing. I don't have a beneficiary, therefore my wife gets it. He doesn't have any beneficiary form on file. He dies. His wife, Sue, goes to the TSP, wants the money, and they have a beneficiary form with Kate's name on it. Who's going to get the money? I don't know. I really hope it's Sue, right? But there's a lot of court cases that says the custodian pays the beneficiaries they have on file. I hope to never find out. Here's what I would like in my camp. If God forbid, if that happens, I'd like a signed beneficiary form that says Bob dies, all the money goes to Sue. And we have evidence that says, no, TSP, you've made a mistake. I have a beneficiary form that says I'm supposed to be the beneficiary and it's valid. Yes, there could be other issues with that, but at least it's something. So Robin, in this case, I like documentation that these things are done, especially when you have many moving parts. I got TSPs, I got 401ks, I got IRAs, I got bank accounts, I got real estate. You have a lot of different moving parts. I want to see those documentation that everything is put together correctly. So I'm still going to highly recommend that you get it. All right, let's move on to your other question about a trust and how this should be set up. Now, trusts are really good. They're generally a cornerstone in your financial plan. So if I kind of draw out what this should look like, forgive me, I went to school for math, not for art. So we have Bob and Sue inside of this case, and then they have created a revocable living trust. So a couple different ways that things can be set up. The Revocable Living Trust, the way it's designed, it's kind of the cornerstone inside of your estate plan. It kind of helps take care of everything. And it says when the two of you pass away, everything goes down to the trust. Then inside of the trust, we have our beneficiaries. And then with our beneficiaries, we can have conditions, right? How can they receive the money? I have two amazing kids, 14 and 12. While I think they're great, if Kelly, my wife, and I pass away, I'm not going to leave them $1 million at 18 and hope to make good decisions. I have a trust in place because I'm controlling from the grave, right? I have a carrot and a stick and it's dollar signs. Follow my guidance from the grave and then you'll get money. If you don't listen, then you won't get money, right? Now you could say that's mean, but it's my money. And this is your money. So how do you want to set this up and how do you want to set kids up for success? That's one reason a trust is really, really important. Could be a child with special needs is another reason a trust could be important. We cannot give them money directly, cause a whole bunch of Medicaid issues. This could be spendthrift positions. This could be a blended family. You know, Bob and Sue have kids of their own from different relationships. Now they've come together. Okay, now a trust is probably more important to make sure one side of the family tree doesn't get disinherited. So a lot of great reasons as to why we would want a trust. But we have a trust. Now the question is, we have our TSP accounts. Where do we put those and how do we put the beneficiary? Bob's the federal employee in my example, it's his TSP. Most of the time what I like to see is I like to see the spouse as the primary beneficiary, and then I like to see the trust as the contingent beneficiary. A lot of pros and cons to this, but that's normally what I like to see. Here's a really big caveat. Your trust, this right here, must be set up to hold retirement accounts. I have seen dozens of times where clients have hired attorneys who do estate planning, but they're not estate planning attorneys. Big difference here. They're attorneys that says, yeah, I can do an estate plan. They build a trust. The trust cannot hold retirement accounts. What does that mean? If you have a pre-taxed account, a TSP, an IRA, a 401k, and that money goes to a trust and the trust cannot hold retirement accounts, it's forced distribution all at once. All of the money has to come out and be taxed in 1 year, and it's taxed at a trust tax rate, which is dramatically higher than the individual rate. And so all of a sudden, half of that money is gone to IRS. I guess on one hand, thank you so much for paying with the national debt, but you may not want to do this with all of your money. So you got to be really careful in how this is worded, how this is drafted, and make sure it's set up correctly. So trusts are fantastic. I have one personally. I have a lot of clients that have them. I have a lot of clients that don't have them because they're not needed. It is a tool in the tool chest. So you really got to look and say, God forbid, but when you and your wife pass away, you and your spouse pass away, what do you want to see happen? I have a lot of single ladies that also have trust because they want to be concerned on how their money gets spent after they pass away. They want to make sure certain things get done. That is where trust can be really, really powerful. Robin, thank you so much for this great question. If you have a question like this, make sure you jump on our website and submit that question, and you could be featured in the next FERS Federal Fact Check. Till next time, happy planning.